Good afternoon and welcome to this special session of the First District Court of Appeal at the Florida State University College of Law. We are delighted to be here to hear the case today. We have one case on our docket today, and that is Stanley Victor McDaniels versus the state of Florida. Counsel, if you're ready, you may proceed.
Thank you, Your Honor. Eric Friday on behalf, along with my co-counsel Chris Crawford, on behalf of Stanley McDaniels, and I'd ask to reserve 5 minutes for rebuttal.
So noted.
Your Honor, as the U.S. Supreme Court stated in Bruin, it is the balance struck by the traditions of the American people that demands this court's unqualified deference, not a 1987 legislative enactment. The Florida Supreme Court's 2017 analytical methodology in Norman was expressly rejected by the Bruin Court. Norman cannot stand and is not binding precedent given the rejection of its analytical methodology. At the time Stanley McDaniels was arrested, Florida's firearm regulatory scheme, including its ban on open carry, operated to completely ban the lawful carry of firearms both inside and outside the home, except as a licensed privilege to carry a concealed handgun or an affirmative defense. Even with the recent changes in Florida's statutory scheme, it bans the lawful carry of all classes of firearms except for concealed handguns anywhere in the state. Heller rejected such wide restrictions. It found that the restriction on just one class of firearms, handguns, while still allowing rifles and shotguns in residents' homes, was still a constitutional violation. If a ban on only one class of arms cannot stand, then certainly a ban on all but one class of arms must also fail.
Well, counsel, why don't we begin with the state's argument that your client, is not able to bring an as-applied challenge in this case. Can you explain to me and to the court why that may or may not be the case?
Your Honor, there is no reason that Mr. McDaniels cannot bring both an as-applied and a facial challenge. Both issues were preserved in the motion to dismiss that the court denied, the trial court denied, relying on the Florida Supreme Court's decision in Norman because the state failed at the one job that Bruin told it had. And this is laid out clearly in the record in the motion to dismiss and the judge's order. The state offered no, not even one, historical analog to justify Florida's open carry ban.
Well, the state argues that the historical analog is the ban on concealed weapons, and that there were many laws at the time of the founding that did ban concealed weapons, and they say that it really is, it's a restriction that the state can impose on the manner of carry.
Okay.
Why isn't that a historical analog?
Well, so, Your Honor, I would point to the 7 state Supreme Court cases from 1822 to the late 1800s. Every one of these cases struck down not a ban on open carry, because open carry was generally allowed in most of those cases. It only, let me rephrase, those 7 Supreme Court cases all said that the state could regulate concealed carry. Not one of them ever allowed the state to regulate or restrict open carry, only concealed.
Well, let me re-ask the question, because the state, I think, concedes that those are different manners of carrying, concealed or open, but the state's argument is that this historical analog doesn't need to be an identical twin, and the Bruin court said that, but it is enough of a historical analog to allow the state to regulate, quote, the manner of carry.
And I would respond in two parts to that, Your Honor. Number one, the founders themselves and their historical tradition at the time allowed for not a restriction on the manner of bearing arms, it allowed for a restriction on the concealed carry of arms. And if you look at the Cooley analysis that the state supplied in its own appendix, it talks about only secretly bearing of arms were disallowed. If you read any of those cases, some of them actually go into the concept that according to the founding era, there was a certain criminal class that concealed carried arms, but that the good law-abiding citizens openly carried their firearms. And in fact, that was the law in Florida up until 1987, was that open carry was generally allowed. If you even look at Florida's history at one point when it put a tax on the concealed and open carry of firearms, according to the state's own appendix, a $250 tax for the concealed carry of arms, but only a $10 tax on the open carry of arms.
So, Counsel, based on the antebellum case law that you would like us to rely upon, could the state of Florida categorically ban concealed carry if it permitted some reasonable form of open carry?
So, Your Honor, what you're asking about is what we call the alternate outlet theory. And to the extent the state seeks to advance an alternate outlet theory, it's their burden to demonstrate that the founders would have recognized such a theory. Can we pick or choose? At one time, the idea of concealed carry could be heavily restricted, certainly. If we go back to all these founding era statutes and those 7 state Supreme Court cases during the early to late 1800s, the answer would have been yes, generally at that point. Is that necessarily true today? Certainly, the Bruen case could stand for the proposition that the state may license the concealed carry of arms. And I would point this court to, for example, Justice Breyer's dissent in Bruen, where he points out even New York, the state at issue in the Bruen case, allows permitless, unlicensed open carry of rifles and shotguns. It only licenses the open or concealed carry or restricts the open carry, but only licenses the concealed carry of handguns. It does not restrict all long guns as Florida's ban does. So to answer the court's question, potentially the legislature can put restrictions on concealed carry historically. We've seen that. Every court to consider it has upheld that restriction on when it's an objective basis. I think that the state's actions, and I understand it's the Attorney General here today, not the Department of Agriculture, but this court's own, in some cases, en banc rulings and consistent rulings over the last several years, I think have demonstrated that the concealed carry license in Florida is not necessarily an objective license, because this court has had to take multiple actions to restrict or to tamp down on improper conduct by the Department of Agriculture in the issuance of Florida concealed carry licenses.
Well, let's go back to the state's argument on the manner of carry. Can a state regulate and restrict the manner of open carry? So, for example, could a state say you can carry a firearm, but you can't carry it loaded? You need to carry your ammunition in your pocket or a separate bag.
Well, I think Heller answers that question, Your Honor, because Heller, one of the restrictions was having to keep certain guns unloaded in the home, for example, and the court said that rendered them basically useless for self-defense, and so that is not an acceptable answer. Same with requirements that a gun must be locked up, and even when a person wants to carry it on them, it renders it useless for self-defense. So the answer to that is no. Could the state permissibly, for example, require that openly carried pistols be in a holster as opposed to just stuck in the waistband? Potentially, yes. That might come within, depending on the exact regulation, that might come within the sphere of permissible regulation. Some of the historical analogs, which were founded with clearly racist roots, one of the historical analogs was that restrictions on only Army and Navy pistols could be carried in one case. Now, that was an antebellum statute because those particular pistols were particularly expensive and also very large pistols, not necessarily suitable for concealed carry. And so in that case, could there be some restriction that the legislature could pass to require, for example, still employing the sensitive places doctrine that the Supreme Court has upheld? Can the state restrict where guns are carried? Absolutely, within constitutional standards it can, and so to the extent it regulates the manner of bearing arms by restricting certain places within constitutional parameters, absolutely. And I think the same answer applies to, for example, requiring a holster potentially.
Let me take you back to the facial constitutional issue quickly. How do you have standing for a facial constitutional challenge?
Your Honor, I believe that Mr. McDaniels is allowed to make just as Rahimi was a facial challenge. And this court actually allowed supplemental briefing based on the state's request. A facial challenge can be brought in a criminal case. I don't believe there's any. Is it normally is it necessarily common? Is it always allowed? Not necessarily, but I'm not aware of any case that says a facial challenge can never be brought when an individual believes that the law is facially unconstitutional just because they're being prosecuted in a criminal case.
Well, I could think of a classic facial constitutional challenge here for an individual 18 to 21 who's barred from any, arguably, their Second Amendment rights are being violated because they're not allowed to open carry or concealed carry, but your client's not 18 to 21, so.
Well, so, Your Honor, if the question is, and I'm not sure if the court's aware, but the facial issue as to 18 to 20-year-olds is being challenged, is currently before the 11th Circuit Court of Appeals on an en banc status. Individuals who are in that 18 to 20 category can certainly raise a facial challenge that they are being denied, that the ban on based on their age is a facially unconstitutional statute. Similarly with Mr. McDaniels, he has raised the issue that the open carry ban, when considered in pari materia with Florida's regulatory scheme, that the open carry ban is facially unconstitutional. The state tries to save it from a facial challenge by saying, well, certain categories of people can be prohibited and therefore they can't open carry either. But I don't think that the court should go to hypotheticals and what ifs of, well, there are other laws that also impact that particular person. So for example, yes, a felon can't open carry either, but there's already a statute that says felons can't possess firearms. So I don't think that that application, as the state argues in their brief, necessarily carries over to say that the open carry ban is not unconstitutional in all its facets, because it's not that a felon can open carry, it's that a felon can't carry at all.
Counsel, let me take you back to Norman.
Yes, Your Honor.
So address the state's cases that say, and one even expressly says that in that case it was Nelson, in our case it's Norman, is still binding precedent unless and until SCOTUS weighs in on an open carry law or Florida Supreme Court revisits its Norman decision.
Yeah. Your Honor, and I have to take issue with the state has taken significant steps to prevent this issue from being heard in civil litigation. And so now they want to restrict what can be brought up in criminal litigation after also avoiding it in civil. The case of Carana v. Chitwood out of the 5th DCA, for example, the court exercised its gatekeeping function and said that under the declaratory judgment statute it was going to exercise gatekeeping and not let this case proceed, so they dismissed the case. The 5th DCA per curiam affirmed that decision, and so there was no opportunity to appeal that back to the Supreme Court to have the issue readdressed in light of Bruin. Now the Gun Owners of America organization and Mr. Hughes have brought a case in the Southern District of Florida, and the state has filed briefs in that case moving to dismiss that case on the grounds that, well, there's this case today, and there's another case out of the 5th DCA in Orlando, and based on those two, or excuse me, I believe it's 6th DCA now, based on those two cases, younger abstention doctrine should apply, even though there are no connections between the defendants in these two criminal cases and the plaintiffs and organizations in that civil case. So the Attorney General's office, the state attorneys involved in those that are defendants in those cases, are doing everything to avoid these cases from being heard and from having this issue addressed and having.
Counsel, I think we understand that, and I'm going to extend your time by 5 minutes and the same thing for the state. I think the question is, does the Florida State Supreme Court's decision in Norman bind us, or does the U.S. Supreme Court's decision in Bruin allow us to look past Norman and decide this case on the merits?
Your Honors, I think when we look at the Norman majority versus the Norman dissent, and there's a quote in one of my briefs that sometimes a dissent is an appeal to a future court to take action and to do the right thing when the wrong thing is done in the first instance. And we have seen numerous examples that the Florida Supreme Court itself has reversed that prior majority that existed in the Norman case in recent years. And Your Honors, I have to say that given the analytical reasoning and the interest balancing applied in Norman that was expressly rejected by Bruin. Bruin is very clear. Stop the interest balancing that you lower courts and state courts are doing. It's not appropriate, it's not constitutional, and it does not comport with the U.S. Supreme Court's analysis of the Second Amendment issue. And given that express rejection of that analytical reasoning, the lack of analogical reasoning for similar laws, and the improper interest balancing, I believe that the Supreme Court's Bruin ruling is more than sufficient to overrule what the Norman court said, given its rationale.
The simple answer be, this is a federal constitutional law question. Therefore, we are bound by the U.S. Supreme Court.
Yes, Your Honor, that's absolute. That would be a simple answer.
I know of no case in which the Florida Supreme Court has said you will follow our precedent, even in a federal constitutional law scenario. In fact, this court in Spitzer versus State some time ago made that point and said we're bound by the U.S. Supreme Court when you are dealing with a federal constitutional law interpretation.
And I think that's exactly the right answer, Your Honor, along with the fact that heavily at issue in Norman was the Article 1, Section 8 language about the manner of bearing arms being regulatable under the Florida Constitution. And to the extent that the U.S. Supreme Court has now said, here's the cases you need to look at, here's the analogical reasoning, here's the historical type tradition you need to be able to find. Given that, I think that's absolutely correct, Your Honor. We're now dealing with more of a federal issue in this case than where Norman was more tied to, in many ways, the Article 1, Section 8 provisions. Second Amendment was definitely an issue in Norman, but I think the court focused more heavily on the manner of bearing arms permissibility of the Florida Constitution. And Your Honors, I'm not sure about the clock and what my time is at this point, but
3:50.
Okay, thank you, Your Honor. We would ask this court to reverse this conviction, find that 790-053 is unconstitutional, both facially and as applied, and find that the conviction in this case should be vacated. Thank you.
And let me correct for the record, it's now 8:34, so it has been adjusted.
Okay, thank you, Your Honor.
You're welcome. You may proceed.
Thank you, Your Honors. Kevin Golombiewski for the state of Florida. The only question presented in this case is whether Mr. McDaniel's conviction under Section 790-053, which limits open carry in the state of Florida, violates the Second Amendment. He was not affected by any other part of Chapter 790 or made no showing that other parts of Chapter 790 at that time contributed to his conviction. And so the only question is about this limit on open carry. In Norman, we do believe resolves that question because, as Judge Thomas noted, Bruin certainly says that courts must apply the history and tradition test moving forward when working on a blank slate. But here, there's an on-point holding from a higher court that Bruin has not abrogated. Nothing, in other words, in Norman's holding that this law is consistent with the Second Amendment is irreconcilable with Bruin or Rahimi, even though we admit that the Florida Supreme Court applied a methodology that's been disavowed.
But let's wait a second on that. I mean, the entire reason the United States Supreme Court took Bruin was to discuss the two-step analysis being applied in all of the federal circuits, being applied by the Florida Supreme Court in Norman, and it expressly held that there's one step, and that deference is required to the people who ratified the Constitution, not to state legislatures. Norman unmistakably applies two steps. So why isn't Bruin a complete game changer in this case?
It's certainly, I certainly agree that it abrogates the methodology. I think our view is that it does not touch the ultimate holding.
But the ultimate holding rests on an analytical framework, correct?
Yes, Your
That
Honor.
analytical framework has been repudiated by the United States Supreme Court. So under the Supremacy Clause, how can we ignore the United States Supreme Court's methodology that it is required for Second Amendment cases in deciding this case solely because we have a Florida Supreme Court opinion that relied on a now repudiated framework?
Well, I think your points, Your Honor, certainly show that Norman might be of much weakened precedential value. Our view is that if there can be different views of the holding in Norman and how much it's tied to the flawed methodology, the role of the DCA should be to defer to that Florida Supreme Court precedent and leave it to the Florida Supreme Court to revisit that precedent. And if it decides that any precedential effect that's left must be gone because of Bruin, that's the Florida Supreme Court's decision to make. In the cases we cite...
But, I mean, we swear to uphold and defend the United States Constitution as well as the state Constitution of Florida. So, I mean, we can just look past what the United States Supreme Court is directing us to do. Is that your argument?
Our argument is that the holding in Norman remains, and this court must defer to it, even because it could still be consistent with the Bruin history and tradition test. And in fact,
let's start there then. Okay, so let's assume we disagree with you. On the historical analog, right? The Bruin majority made clear it doesn't need to be an identical twin in terms of the historical analog, but this isn't a sister. This isn't a twin. I mean, at best, this is an ugly stepsister. It's diametrically opposed to the historical analog that the state argued here. The state argued that the historical analog was the concealed carry statute, right? And statutes that were in place at the time of the founding. There is no historical analog banning open carry.
that is correct. We have not identified a historical ban on open carry, Your Honor. But we think that under Rahimi, I think Your Honor's questions to Mr. McDaniel's counsel were on point in that the real question here is the level of generality, the right level of generality to think about this problem. And so I think Rahimi was very instructive because it built on Bruin. Bruin established the history and tradition test, and then Rahimi explained the right level of generality. And it noted that post-Bruin, many courts had focused in on specific differences for arms-bearing conduct between a historical law and a modern law. But Rahimi instructed courts to zoom out and examine whether the laws generally work in the same way. And we think through that level of generality, these laws are very close. They limit or they regulate the exact same conduct, how arms are worn in public, and they impose a very similar limitation, simply limiting whether you can wear your arm under or outside of your clothing. And I think that the Rahimi analysis of the law at issue there is very instructive. The court there addressed a domestic violence disarmament law that temporarily disarmed individuals that were under a domestic violence restraining order. And the court found as historical analogs surety laws and going armed laws. Even though the surety laws only imposed a financial penalty and required a bond to be paid by the individual to carry, the court found that was sufficiently similar to a disarmament law, even though those have much different consequences.
But I think the difference here, I mean, openly carrying and concealed carry are completely opposite. I mean, what could be more, is there anything in the middle, right? This isn't a identical twin versus sister kind of analog question. These are completely different. So you're saying the level of generality required in Rahimi requires us to go from, 5 feet away to 10,000 feet away, that's general enough?
I disagree with that, Your Honor. I don't think that level of generality is that broad, but I think what the court has to look at is the why and the how and see what's the underlying principle that the concealed carry bans and other manner restrictions that we've identified stand for. And our view is what Bruin said, that those restrictions stand for the proposition that you can limit the manner of carry so long as you don't frustrate the right to armed self-defense in public.
The antebellum case law, which we can look to get kind of the common law of that time, suggests that a ban on open carry was categorically unconstitutional. So they weren't fungible. Concealed carry and open carry were not fungible concepts, at least during the antebellum period. Do you disagree with that?
I disagree with that as a constitutional matter, Your Honor. And so the cases that McDaniel cites include Nunn and Reed, the Alabama and Georgia Supreme Court cases. And Bruin passed on those cases and noted that they stand for the proposition that you couldn't ban both concealed and open carry because that would altogether frustrate the right. But to be sure, we recognize, as Your Honor is noting, that there's some language in those decisions that suggests those courts in the 1840s believed open carry had some constitutional protection. But just as Rahimi instructs, I think we have to look at, when we're looking at regulations and historical cases, at what's the underlying constitutional principle. And Reed, for example, when making this statement, said, at that time, open carry was the efficient means of self-defense, which reflected modern circumstances that, as we note in our briefs, concealed carry was associated with criminals who typically carried pocket pistols, and law-abiding citizens carried larger arms, including military, Army or Navy pistols that were 16 inches long and couldn't be readily concealed. And so it makes good sense when the historical context is taken into account that it would have been seen as violating the right to armed defense if open carry was limited. And so that we think evinces the principle that supports our law, and that our position.
Well, aren't you stretching Rahimi? I mean, basically what you're doing is circumventing the U.S. Supreme Court's declaration that historical analog is our focus. And so basically what you're saying is, with this modern approach, isn't that just trying to circumvent exactly, contrary to what we've been instructed in Bruin?
I don't think so, Your Honor, because I think that the historical analog approach that Rahimi laid out is saying that you look to the historical analogs and the underlying constitutional principle that they represent. And so these cases, Nunn and Reed, we think stand for the proposition that there's this principle that you can regulate the manner of carry so long as you don't frustrate self-defense. And then
isn't it more than that? I mean, aren't those cases dealing with concealed carry? The concern at the time of the founding was kind of the furtive stealthiness of concealed carry. So it wasn't just a manner of carry regulation. There was conduct that the states that were, passing these concealed carry laws were seeking to address. That's not present with open carry.
So, Your Honor, I think that this goes to the why, and of course we agree, like Judge Thomas has mentioned, that we have to adhere to the why and the how in the analogical inquiry. And the why that I think Your Honor is espousing is too specific a level of generality, and I think Rahimi is helpful for us on this point. So Rahimi, the law at issue was the domestic violence disarmament law, and the Fifth Circuit Court of Appeals explained the why as preventing domestic gun abuse. So the very specific underlying rationale. But the U.S. Supreme Court rejected that and zoomed out a level and said the why is mitigating gun use by individuals who pose a credible threat of danger. And so mapping that onto here, we think that the specific why underlying the concealed carry bans to prevent ambushes, that's too narrow a focus. And instead, the why is zooming out a level and looking at the general class of conduct or persons the law addresses on its face. And that conduct here is ensuring public carry in a safe manner. And we think that this is very consistent with the history and tradition test because it requires courts to just look at what the face of the law targets instead of trying to discern legislative intent about the underlying rationale. And that was a big problem with, I think, some of the means and scrutiny cases.
Doesn't that do violence to the plain text of the Second Amendment, though? I mean, it's more than just the personal individual right to carry. It's the militia right as well. It's the bearing arms. So this analysis, what you're trying to zoom out from the purpose and intent of the bans on concealed carry, what does that do to the other rights that are present under the Second Amendment?
Well, we think that the core component of the right, based on Heller and McDonald, is self-defense. And so I think zooming out and viewing the why and the how through the lens of, well, does this impose a comparable burden on the right of armed self-defense is consistent with Heller and Bruin. And I'd also like to kind of turn to the example that you gave, Judge Rowe, about, well, what about a ban on holding ammunition in your firearm in public? Because I think this is illustrative. So we think that that would be a different in-kind regulation than we have here. So we're regulating how arms are worn, but that type of example starts to feel like a different category in a use restriction. And I think that is another helpful way to think about this problem of laws within the same general tradition or category are analogous, even if they're not twins or even cousins, as Justice Barrett said in her concurrence in Rahimi. And so a law like that might start to look outside the historical tradition because it does impede ready use of an arm for purposes of self-defense, which is the core of the right.
But if the legislature were to pass that law, you'd be here arguing that in fact, it is a cousin, and in fact, that it is, Rahimi's general enough, if you zoom out enough, that is also a manner of carry type of case, would you not?
Well, I work for the state, so I might be doing that, but I think that it would be a much more difficult argument for us because, at least on the research I've done so far for this case, there might not be that historical evidence. I don't know if it's out there because I focus so much on the manner of carry for this case, but I think the evidence that we've compiled for this case, it would be a hard argument for us to say that it lends itself to justifying such a restriction on use, or that actually stops an individual from deploying their weapon for self-defense. And one important point that we made in our answer brief is that today, an individual can carry their handgun, which Heller says the quintessential self-defense weapon, just as readily in a holster under or outside their clothing and deploy it for self-defense. But Mr. McDaniels didn't respond to that or contest that in his reply, and instead focused on the idea that there is a very specific right to open carry instead of engaging with the self-defense piece of it.
And there may be a good reason I know my colleagues probably have some questions as well, but I mean, really, so is it your view that Heller and McDonald and Bruen and Rahimi are limited to a right of self-defense, and that is all that the Second Amendment protects in terms of carrying arms?
Well, no, it also certainly includes the right to publicly carry, and as Heller said, the right to have your handgun in your home. But I think the through line through a lot of these, at least through the Bruen analysis, what Bruen's articulated so far is when you're looking at the comparable burdens, you're looking at the burden on self-defense. And so just, if that's the test, that's why we're focused on self-defense. We're just taking our lead from Bruen in that respect. I'd also just want to, I started out discussing that this challenge is focused on 053 and the open carry limitation. And so another piece that's been raised at times by Mr. McDaniels is the effects of the law on long arms. But this court doesn't need to reach any questions related to long arms. Even if Mr. McDaniels has preserved an as-applied challenge, he was carrying a handgun in public. And as for the facial challenge, we know from Rahimi that the Salerno standard applies to this case, and so if there's any valid application of the law, it withstands the facial challenge. And based on the analogical inquiry, we think it's plain that the concealed carry bans as applied to individuals with handguns impose just the same burden as our open carry law on individuals like Mr. McDaniels who are carrying a handgun. And so this case in that respect is very, very similar to Rahimi, where the court concluded that, well, the facts in front of us are a valid application of that domestic violence disarmament law, and the facts in front of this court, where an individual was carrying a handgun publicly and not a long arm, are plainly a valid application that's consistent with history and tradition because it does not infringe the right to armed self-defense.
So, counsel, Justice Kennedy and then Justice Polson's dissent in Norman drew on some of the antebellum case law to stand for the proposition that a ban on open carry is, in fact, unconstitutional. How is their reasoning flawed in that case?
I think the reasoning really mirrors Justice Thomas's in his dissent in Rahimi, Your Honor, where and this goes back to level of generality, I think that they're focused on too specific a level of generality, and Justice Kennedy noted in that decision, and he had support for this at the time, that in order to properly carry out a history and tradition or originalist inquiry, you need to look at the most specific level of regulation historically, and there was some good sense to that because that could be an objective way to approach this. But I think that now with Bruen saying a historical twin is not required, that rejects that very specific level, and then Rahimi certainly rejects it because it expressly said that courts, by parsing levels, the historical regulations at that level of specificity, took a wrong turn, and instead courts should be looking for the constitutional principles underlying the historical statutes. And I think that some of the concurrences in Rahimi lay out the why behind this, I thought, pretty persuasively, and that's The historical statutes, and I think that this is a flaw in Mr. McDaniel's position, the historical statutes aren't themselves a constitutional rule. They're an application of a constitutional rule or principle. And so the concealed carry bans don't themselves establish a law trapped in amber that we can only regulate concealed carry. Instead, they evince an application of some broader constitutional principle. And we think that Bruin really lays this out because it talked about these concealed carry bans as standing for a broader principle that you can regulate one manner of carry so long as you don't thwart the right to armed self-defense or prevent public carry altogether. And our law, we think, fits comfortably within that tradition because of how close. We're regulating both just the wearing of arms. It's not some different type of manner restriction that starts to pose problems. And we're just doing it in relation to an individual's clothing. So for those reasons, we think that not only is this court bound by Norman, but also 053 satisfies the history and tradition test under Bruin and Rahimi.
Do you concede this is a federal constitutional law question?
Yes, Your Honor. Yes, Your Honor. And on the Norman point,
And with that concession, Bruin controls.
I disagree, Your Honor. I don't think Bruin controls because it has not spoken to the question in this case, the ultimate question of whether 053 is consistent with the Second Amendment, whereas Norman has, and I think the Supreme Court cases we cite, for example, the Rodriguez case explains, when there's an on-point precedent and then there's another decision disavowing or undermining the reasoning of that on-point precedent, that precedent is still binding on lower courts. And so I think we see this as a rule of precedent or orderliness where we completely agree that the Florida Supreme Court could recede from Norman and say Norman's no longer good law, but because Bruin didn't speak to the exact question presented here, we think that opinion still has some precedential effect such that it binds the DCAs. And another example is the Kurtz case we cited, which was a sovereign immunity case, where the Supreme Court said there that one of its prior sovereign immunity cases, the methodological approach had been repeatedly disavowed, yet it still had some stare decisis effect. And so it had to be applied. And we think that the same holds here with Norman. But if the court didn't agree on Norman and didn't agree on parts of our history and tradition analysis, we still think the facial challenge fails because, for example, our law can be applied to individuals who openly carry in sensitive places. And that particular application is consistent with history and tradition, something that Rahimi and Bruin both reaffirmed. We have a long-standing, well-established tradition of regulating carriage in sensitive places. And just Mr. McDaniel's response to that in his reply was, well, this isn't a location-based law, and so that analysis is irrelevant. But Salerno is not concerned with the main thrust or sweep of the law. The task is to look at the statute and assess, can it be applied in this valid manner? And we believe that our law certainly can, as well as it can certainly be applied to individuals who are openly carrying with handguns like Mr. McDaniel's.
But if we disagree with you on Norman, and if we disagree with you on, what is the proper historical analog, what of the as-applied challenge?
As of the as-applied challenge, so we think it's not preserved either below or here because Mr. McDaniel's never spelled out or identified, well, which specific facts does he think render this case appropriate for as-applied relief, or explained his argument as to why he's entitled to that relief. And so,
He was convicted, right?
Yes, Your Honor.
Right, so this isn't a civil case, this is a criminal conviction where he was convicted on the statute that he now challenges the constitutionality of, right?
Yes, Your Honor.
Okay, so what are we missing here in your as-applied argument and preservation?
Well, so the DCAs have explained that even in a criminal case, an individual needs to identify and make this as-applied argument below so that the trial court can have a chance to pass on it. And here the trial court, in the order, never passed on the as-applied challenge. Mr. McDaniel's, in his reply, cites pages 41 through 43 of the record as supporting his claim that the trial court passed on an as-applied challenge. but 41 through 43 only addresses the standing problems with his attempt to challenge other aspects of Chapter 790. And so I guess that's the heart of the argument, Your Honor, is that the trial court never had a chance to assess which specific facts he thinks warrant as-applied relief and then to address that argument. But as we lay out in our brief, the best that we can make of the argument being is that he's a law-abiding citizen and was openly carrying. But those facts are no different than the ordinary facts that would support a facial challenge, for example. And we think the history and tradition would foreclose that claim even if it was preserved. If there's no other questions? Thank you, Your Honors.
Thank you, counsel.
May it please the court, Bruen controls. That's number one. Number two, part of the analogical reasoning test is the how and the why. The state mentioned during its time the how and the why, but it doesn't offer any historical evidence or historical argument for why should there be a connection between banning concealed carry and banning open carry. The case law tells us that the how and the why of banning concealed carry was it was the particular method used by certain people in certain cases to start an argument and to be secretly armed, and that this was a problem that the founders had to address when a person was secretly armed and could start an argument versus when a person was openly armed and people would know, if I have an argument with this person, they are armed and I should not attack them. A deterrent effect, essentially. That same deterrent effect applies to somebody that open carries today. There's a certain deterrent effect that person is armed, that person is probably not the person that a criminal is going to want to attack, and so there's a self-defense component to the open carrying of arms in that deterrence. The state did not argue below, there's nothing in the judge's order on the motion to dismiss, and they have not argued in their briefing before this court any how and why open carry can be banned. They merely say, well, if one method can, then a different method can, as long as that other first method is allowed. That doesn't answer the how and the why that the analogical reasoning requirement of Bruen requires. They say that they can regulate open carry because the state has an interest in regulating a safe manner of carry. That's interest balancing. It's not permitted under Bruen. It's not permitted under Rahimi. It's not permitted in the Second Amendment context anymore. No interest balancing. Show the court how and why a historical connection between some prior restriction and that restriction today. Doesn't have to be a historical twin, yes. May not need to be a close cousin, but at least needs to be a distant cousin, not some Dutch uncle argument that they come in here and make up at the 11th hour. Justice Thomas pointed out the green truck and green hat explanation. If the metric is things that are green, it's a valid connection. If the metric is things that you can wear, a green hat and a green truck are two different things. Open carry and concealed carry are two different things. We have historical rationale for why the courts restricted concealed or allowed the restriction of concealed by legislatures. We have no such analogical argument in relation to the ban on open carry other than today, public carry in a safe manner. There's nothing inherently unsafe about open carry. And in fact, if there was something inherently unsafe about open carry, that's a problem that would have existed at the founding when all of these open carry was generally allowed and concealed was restricted, and yet there was never a restriction on open carry on some argument of public safety.
Could you address counsel's argument and emphasis on Rahimi and distinguish?
Rahimi is a question about, can certain people be restricted from bearing arms? Because in Rahimi's and then the court was very clear, not even a permanent ban, a temporary ban in Rahimi. The court was saying this person was temporarily banned based on a judicial finding that they specifically posed a threat to another problem. Connecting that to surety laws is not some huge leap. That's a very easy connection. Now, the disconnect for me potentially might be, well, the surety law said post a bond, not an absolute ban. But even there, the absolute ban is for a temporary time period until that injunction has been dissolved. And injunctions aren't forever. Even a permanent injunction under Florida law, a permanent domestic violence injunction, has a methodology for a person to come back and vacate it. And there's a wealth of precedent that, you know, when time has passed and there have been no more violations and there's no showing that the person continues to be an imminent threat, that injunction must be vacated.
Could you address the state's argument that the issue of the as-applied challenge is not preserved and that the trial court did not pass on this question?
I agree that the trial court only tangentially addressed the as-applied challenge, but it's in the motion to dismiss, that in the memorandum of law related to the motion to dismiss, that Mr. McDaniels is bringing both a facial and an as-applied challenge. And he lays that's laid out in the motion to dismiss. I don't know what more needs to be done to preserve an as-applied challenge than it's in the motion to dismiss that the court denies and it is then appealed to an appellate court. It's laid out in that memorandum of law, and now it's raised again in the initial brief that as applied to Mr. McDaniels, a person who the legislature has already found to be a responsible, law-abiding citizen, able to bear arms on the public street where he was located, what is the how and the why to justify the state restricting him to only a handgun and requiring that handgun to be concealed as a condition of exercising a fundamental enumerated right that precedes the Constitution and is protected by the Constitution, not a right granted by the Constitution. And that goes back to the Heller and McDonald decisions, that this is a pre-existing right, and it is a right that we the people have reserved to ourselves, regardless of, and this is a quote from Justice Scalia and then Justice Thomas, both, even if taking away from even the third branch to decide whether the right is really worth insisting upon. We the people decided it was worth insisting upon, and that right must be protected. Dicta in Bruin, a case where open carry was allowed of rifles and shotguns, but simply not the pistol that the plaintiff was bringing the challenge to, cannot operate to make the argument that one or the other may be banned when there is absolutely no historical basis for banning open carry. Thank you, Your Honor.
Thank you, counsel. Thank you all. This will conclude our argument for today.